How to appeal a decision in contested divorce case in India. In India, married couples seeking divorce have to file a petition in the family court under the Hindu Marriage Act 1955. If the divorce is contested by one spouse and the family court passes an unfavorable decree, the aggrieved spouse can file an appeal with the High Court. Here is the step by step procedure to file an appeal in a contested divorce in India.
Hello and welcome to Law Nano. We are here to help simplify Indian family law so you can understand your rights and options. Navigating divorce, alimony, child custody, and other family legal matters can be overwhelming. That's why we provide clear, concise information and resources to empower you on your journey. On our website www.lawnano.com, you will find guidebooks plus articles covering key topics like choosing the right lawyer, building your case correctly, and tips to resolve your case effectively. We break down complicated legal stuff into actionable advice you can use. Whether you need help understanding the law or want to know how to get started in a family law case, we have got you covered. The legal process does not have to be confusing. Visit our website today to get the knowledge you need to make informed decisions. Just click the link in the video description below to get started. Now let's continue with the rest of this helpful video.
Grounds for filing appeal. The aggrieved spouse can file an appeal if the family court decree suffers from legal infirmities like error in appreciation of evidence and facts, failure to consider material evidence, violation of procedures prescribed under the law, decision against the principles of natural justice, illegality in the decree. For example, if the family court rejects crucial evidence while passing the divorce decree, it is a ground for appeal. Timeline for filing appeal. As per the section 28 of Hindu Marriage Act, the appeal must be filed within 90 days from the date of decree passed by the family court. For example, if the family court passed the contested divorce decree on 1st January 2023, the last date to file the appeal is 31st March 2023. If there is a delay in filing the appellant must file an application seeking condolation of delay along with a valid reason for the same. Court fees for appeal. The appellant has to pay the prescribed court fees for filing the appeal with High Court. For example, in the Bombay High Court, the court fees is 2% of the value of the original divorce petition. Serving notice of appeal. The appellant must serve a legal notice to respondent spouse informing them about filing the appeal. This gives the respondent a chance to defend the family's court decree. Appeal memorandum submission. An appeal memorandum containing grounds of appeal, background of the case, applicable laws, evidence, judgments, and prayers should be prepared and submitted to the High Court along with supporting documents. Hearing of arguments. The High Court will conduct hearings where both parties get an opportunity to argue their case and examine evidence. For example, the appellant can point out errors in family court's decree while the respondent defends it. Orders passed in appeal. After hearing arguments, the High Court can pass orders like decree reversal, modification, dismissal, additional evidence, or interim orders in a contested divorce appeal. The High Court's decree overrides the family court decree. Conclusion. By filing a properly drafted appeal within the timeline and substantiating it with evidence, the aggrieved spouse has a chance of getting justice from the High Court in a contested divorce case. Hiring an experienced divorce appeal lawyer significantly improves the odds of winning.